GST landmark judicial outlook for the week. Vedanta Limited versus Union of India, DB civil writ petition number 10618/2025, contesting an assessment order that imposed GST on corporate guarantee. Union of India versus HCC BCCL joint venture, diary number 24660/2025, especially when the refund pertains to a electronic cash ledger. The mismatch between GSTR 2A and GSTR 3B. The applicant accused was arrested based on allegation that their firm availed legally vulnerable attract judicial scrutiny, failed to serve a mandatory show cause notice. GST landmark judicial outlook for the week. My dear friends, the first landmark judgment for the week is with respect to Rajasthan High Court. Vedanta Limited versus Union of India, DB civil writ petition number 10618/2025. My dear friends, it was held by Rajasthan High Court. High Court's interim stay over GST demand on corporate guarantees provided by Vedanta. My dear friends, Vedanta Limited filed a writ petition. My dear friends, the facts of the case is Vedanta Limited filed a writ petition contesting an assessment order that imposed GST on corporate guarantee given by a parent company to banks on behalf of its subsidiary, even when no consideration was received. Assessment relied on CBIC circular number 204/16/2003 GST, Schedule 1 of the GST Act, CGST Act, which deemed such guarantees as supplied between related parties liable to GST even without consideration. A very, very important point of consideration in law. If the guarantee is provided between two entities, whether that will amount to supply, that too between the related party, answer is yes. Vedanta questioned the validity of Rule 28 Sub-Rule 2 of the CGST Rules 2017 and the circular, arguing that the presumptive 1% valuation of the guaranteed amount is excessive and economically burdensome. My dear friends, the Rajasthan High Court took note of the submission and granted an interim stay, directing that no GST recovery be made under the impugned assessment order for the time being. So there is an interim stay now. My dear friends, the matter is now posted for final hearing on August 7th with the legality of the valuation mechanism and the circular's enforceability under judicial review. GST landmark judicial outlook number 2 with respect to Supreme Court judgment. Union of India versus HCC BCCL joint venture, diary number 24660/2025. My dear friends, it was held wherein it dismisses Revenue's SLP challenging High Court judgment limiting Commissioner's revisionary powers staying refund sanction order. My dear friends, the facts of the case is the Delhi High Court held that an allegation of wrongful input tax credit availed as no direct correlation with the validity of a refund sanction order, especially when the refund pertains to a electronic cash ledger. The Commissioner cannot exercise revisionary powers under Section 108 of the CGST Act to keep a refund order in abeyance unless it is clearly established that the order is erroneous, improper or prejudicial to the interest of the revenue. Merely receiving a post facto intelligence suggesting possible ITC fraud does not justify staying a previously sanctioned refund, as such inputs do not inherently invalidate the original refund order. My dear friends, the Supreme Court declined to interfere the High Court's decision, affirming that there was no legal basis for the Commissioner's order and reinforcing the safeguards against arbitrary use of revisionary powers. While upholding the High Court's ruling, the Supreme Court clarified that it is not settling the underlying legal question and left the broader issue open for consideration in future cases. GST landmark judicial outlook number 3. My dear friends, Madras High Court in case of GIT Autocom versus Assistant Commissioner WP number 16474/2024. It was held a CA certificate valid for transaction genuineness even if not from the supplier. The Madras High Court quashed the assessment order passed under Section 74 of the CGST Act, observing that the officer had acted mechanically without proper application of mind. The facts of the case is the assessee explained that they could not obtain the required CA certificate from the supplier due to the supplier being under liquidation and hence were unable to contest the mismatch between GSTR 2A and GSTR 3B. Despite the assessee submitting a certificate from the chartered accountant, from their own chartered accountant confirming receipt of goods, payment of GST, completion of transactions, the authority failed to give due consideration to this document. Citing CBIC circular number 183/15/2022 GST, the court stressed that the proper officer should have evaluated the CA certificate and supporting documents before concluding the proceedings instead of dismissing the matter arbitrarily. My dear friends, the matter was remitted back to the Assistant Commissioner Revenue for fresh consideration under Section 73 non-fraudulent cases with the condition that the assessee deposits the disputed tax amount in the interim. GST Landmark Judicial Outlook number 4. It is a case of the Guwahati High Court judgment Varun Goyal versus State of Assam CRL petition number 699 of 2025, wherein it was held interim bail granted as notice under section 35 subsection 3 of the BNSS 2023 was not served and the reasons for arrest were not communicated. My dear friends, the facts of the case is the applicant accused was arrested based on allegation that their firm availed and passed on ineligible input tax credit using invoices without any actual supply of goods, violating section 132 of the CGST Act. My dear friends, the applicant contested the arrest, arguing that the authorization for arrest lacked proper jurisdiction or written recording of reason to believe, thereby undermining legal validity. My dear friends, the court observed there was no compliance with section 135 of section 35 subsection 3 of Bharatiya Nagarik Suraksha Sanhita 2023 BNSS, which mandates prior notice and proper communication of arrest grounds. A mandatory procedural safeguard, even the same is provided under the Constitution of India under Article 20, 21 and 22 of the Constitution of India. My dear friends, while some reasons for arrest were recorded, the court acknowledged procedural differences and deficiencies and ruled that custodial interrogation was not necessary at this stage, leading to the grant of interim bail to the applicant. My dear friends, this case highlights that any arrest under GST must strictly comply with procedural safeguards under BNSS and GST Act, including a documented reason to believe and proper service of notice. Failure to do so can render the arrest legally vulnerable, attract judicial scrutiny. GST Landmark Judicial Outlook number 5. My dear friends, this is about Andhra Pradesh High Court judgment. It was held in Sri Shakti Communication as Assistant Commissioner of State Taxes. Demand order passed without issuing a show cause notice under section 142 subsection 1A is said to be set aside. My dear friends, the facts of the case is the assessing authority failed to serve a mandatory show cause notice, that is SCN, under Rule 142 subsection 1A of the CGST rules before initiating assessment proceedings for financial year 2017-18. My dear friends, the absence of SCN, absence of show cause notice amounted to a breach of the principles of natural justice, as the taxpayer was denied opportunity to respond before the demand was finalized. My dear friends, the revenue did not dispute the claim. Revenue did not dispute the claim that no such notice was served, effectively acknowledging procedural non-compliance. The court relied on established judicial precedents, holding that failure to serve the SCN renders the assessment and demand order legally unsustainable. The demand order was set aside and the matter was remanded back to the assessing authority with direction to conduct fresh assessment in compliance with procedural requirements under the GST Act and the rules. GST Landmark Judicial Outlook number 6. It is with respect to Uttarakhand High Court, wherein JVM Industries versus State of Uttarakhand WP number 120 of 2025. My dear friends, it was held arithmetical error in order leading to excess tax demand allows assessee to seek rectification without limitation. My dear friends, the facts of the case is the assessee identified a clear arithmetical error that caused the tax demand to exceed the actual taxable value of transaction for the period 2018-2019. The court recognized the error as purely clerical or arithmetical in nature, resulting from an accidental slip or omission not involving any substantial legal issue. My dear friends, assessee was entitled to seek rectification under section 161 of the CGST Act, which allows correction of errors apparent on the face of the record. Court held that second proviso to section 161, which exempts such rectification from the 6-month time limit, was directly applicable to this case. The assessee was granted the liberty to file rectification application under second proviso, and the authorities were directed to consider without applying the 6-month limitation period stated in the first proviso. Thank you. Signing off, Advocate Dr. M. Satyakumar.